The federal government says it's filing 2 fresh criminal charges against Nnamdi Kanu, leader of the proscribed indigenous people of Biafra. The fresh charges are being added to the initial 5 counts bordering on treasonable felony and terrorism. The case, which is scheduled for the 21st of October, has caused apprehension amongst socio-cultural groups in the southeast. Reacting to the amended charges, IPOB asked the government to expect legal fireworks on Thursday, while the Ohaneze Ndibo worldwide also called on President Muhammadu Buhari to ensure that Nnamdi Kanu appears in court as scheduled to prove to the global community that the IPOB leader is hale and hearty, and warns against usurping the judicial process.
For high-profile cases such as this, media interests are usually heightened, but more often they are denied access to coverage. To help us understand how to manage high-profile cases such as this, we're joined by a famous Nigerian lawyer and a member of the English Bar Council, Barrister Daniel Bwalan. Daniel, glad to have you join us on the program. Like we described you, you're a member of the Bar of the English Bar Council, a lawyer, and who is knowledgeable about how high-profile cases such as this are handled. Bring us up to speed with how these cases are handled in other climates, particularly in the UK, where you are a member of the Bar Council.
Right, thank you for having me. Just for disclosure, I do not practice in the UK, although I've been admitted to practice by the Lincoln's Inn. And as a matter of fact, next month we have our annual bar conference in England. Generally, trials, especially criminal trials, are meant to be trials that should be conducted in an open court, because justice is only called a justice when it is a justice to the state, justice to the accused, and justice to the public. And fair trial is a trial that is conducted in the public. Now, the entire country cannot come into the courtroom. That's why the members of the press are there to report what transpires in court or the proceedings in court for the purposes of the masses to see and judge for themselves whether there is a fair trial in this instance. I do not think that there is any bar for the members of the press to appear before the court in any criminal trial. And if there is, then that is wrong. There are the only exceptional cases where trials are not conducted in the public where it involves a minor, or sometimes when the national security is threatened, and then it will even have to be by an order of the court. In England, because of the way it is so designed, information is passed. In fact, the media is part of the trial process. So, for example, trial cannot be conducted successfully until there is a place for the men of the press to report to the English public about the administration of justice in that case. So it is organized in such a way that information is given to the members of the press, slot is given to them, seating arrangement is given, the number of the cases is communicated to them, how the trial is going to be conducted, the rules of engagement while they are in the courtroom. For example, they are not supposed to, if they are not supposed to cover it live, they are not supposed to cover it live. If by an order of court or under exceptional cases, the case is going to be covered live, it will be communicated. Who amongst the members of the press that might be permitted to cover live in case others are not. All of that will be communicated ahead of time. But in a nutshell, the members of the press, or the people called the fourth estate of the realm, are not precluded, restricted, or prohibited from not only attending but covering the trial. In Nigeria, the problem we have is that the members of the press, sometimes they are caught up in the drama of the event leading to the trial. And sometimes the security forces will feel that they are now going to be ambushed, or they might feel that the drama that is created around the court before the trial might affect the course of the trial if it is allowed. These are the circumstances or situations under which they will limit the number of press people that will cover. But in a nutshell, the members of the press are not to be prohibited, restricted, or precluded from covering trials in the court. That is the law, and that is the justice.
Thank you for giving us that perspective. Well, recall that after Nnamdi Kanu's rendition, he was billed to appear in court. It was a no-show The reason that was given was logistics and all of that. Now, Ohanaeze is insisting that there should be proof of life, asking that the government should ensure that Nnamdi Kanu, appears in court in the next court date. What do you think would be the implication if there is a no-show again come October 21st? What would that mean for his right, to trial and fair hearing?
First of all, the trial cannot be conducted in his absence because it's a criminal trial. The accused must be present in court. And now that we're hearing that the federal government has filed additional charges, he must be seen physically in court so that the charges will be read to him and he will be asked to enter his plea of guilt or plea of not guilty. So there is no way the trials and the charges can be read in his absence. That's number one. Regarding the protests of Ndigbo, that's Ohanaeze Ndigbo, I'm not sure if their demand is part of the trial process in the court. Now, whether Nnamdi Kanu is alive, not alive, healthy or not healthy, is matter that can best be reported to the court by his lawyer, because by law, the lawyer should have access to Nnamdi Kanu. And the last time I checked, I think the lawyers had access to him, they interviewed him, they had communications with him. So, for example, as the trial is coming up day after tomorrow, I assume that the lawyers of Nnamdi Kanu must have been able to see him in preparation for the trial, because one of the conditions for bail is that the accused person, if the accused person is asking for bail, is to enable him have access to his lawyers and prepare to defend his matter. Now, this is not a case where the bail is granted. He's in custody. And I'm sure what will be debated as to will be whether or not he has violated the bail condition and he will never enjoy bail. But we haven't gone to that point yet. But all I'm saying in a nutshell is that on the next date, if the charges are going to be read, Nnamdi Kanu must be present in court. If for any reason Nnamdi Kanu cannot be brought to the court, there is no way the trial can continue, because criminal trial cannot proceed in the absence of the accused person. And the excuse as to whether he will appear or not now will depend on those people that have him in custody, the situation that is under, and his lawyer, and or the court itself. If, for example, the court is not ready to proceed, then there may not be need for him to be brought to the court. But if the court is sitting and everything is intact, then there is no reason why Nnamdi Kanu cannot be brought to the court to take his plea on the new charges that have been filed against him.
All right, Daniel Bwala, member English Bar, thank you very much for joining us on Newsnight tonight.